Hello viewers, welcome back to this immigration program here on AIL TV. As you know, this is part of a series of programs that we'll have on the topic of immigration law because it is quite a hot topic in this country. In the last program, we talked about the reforms that were brought about by the Immigration Act of 2014. There are quite some significant changes that were introduced by that act, and we did talk about some of them, not all of them. So today we're just going to also talk about some of the changes that have been introduced since the last program was aired. There's been more reforms and more changes since the last program was aired, and today we'll just quickly go over some of those reforms, and in future programs we'll then talk about the different types of applications that people can make. As you know, 2014 in immigration law was quite a busy year as the government was busy changing the immigration rules in a bid to actually reduce net migration. One of the areas that the government wanted to reform was the area of citizenship. If you watch news, you would have heard the government saying that as far as they are concerned, British citizenship is a privilege, it's not a right. So some changes, major changes have been introduced, and I think we did talk about some of them. In December, changes were introduced to affect the way applications for British citizenship are decided by the Home Office. As you know, for a person to be eligible for British citizenship, there are certain requirements that they have to satisfy. One of those requirements is that the applicant must be a person of good character. Now, what the Home Office has done is they've quietly introduced changes to the good character assessment. They've added a number of behaviors that would disqualify a person from getting citizenship after living in the UK for 6 years. Those who are disqualified will have to wait for 10 years before they can apply or become eligible for British citizenship. Now, the disqualifying behavior, I'll just go over that behavior. They are talking about people who assist in illegal migration. Yes, those who assist other people to enter the UK illegally. If it is known to the Home Office at the time of application that an applicant has actually been involved in assisting illegal migration, that would disqualify the person from obtaining British citizenship on the basis that they are not considered to be a person of good character. Another behavior that will be taken into account when assessing these applications is illegal entry. For those who enter the UK illegally, that is something that will be used against you when the time comes for you to apply, when you apply for British citizenship. Anyone who has entered the UK illegally, if you apply for citizenship, you will be disqualified. The application will be refused. You'll be disqualified for a period of 10 years. Another category is for people who have breached immigration conditions attached to their leave to remain or to their visas. For instance, if a student is allowed to work 20 hours a week and they work 30 hours a week, when the time comes and they apply for British citizenship, if the Home Office has it on record that at some point during their stay when they were a student, doesn't matter how long ago it was, if it is on the Home Office record that the student, it was known to the Home Office that the student was working over the permitted hours in breach of their stay, that is something that they now can take into account to refuse a British citizenship application. Now, that's just an example of where breaching a condition of a person's leave to remain or visa will be taken into account. There are other things that they will take into account, such as failure to report for those who are required to report to an immigration officer. If you fail to report in the future, if you should apply for British citizenship, if that's on your record, they can use that as well to refuse your application. Those who were working without permission to work, that can also be taken into account in the good character assessment for a British citizenship application. Like I said, the plan is that if a person is disqualified, they will not be eligible for British citizenship for a period of 10 years. At the moment, if a person has lived in the UK for at least 6 years, having finished 5 years with limited leave to remain and 12 months with indefinite leave to remain, they can then apply for their British citizenship. So if you are disqualified, it means you have to wait a bit longer. You wait 4 more years. You make it 10 years instead. And the 10 years starts counting from the time you were encountered or you became known to the Home Office. So let's say a person entered the UK illegally 20 years ago, and they did not come to the attention of the Home Office until maybe 10 years later or 2 years ago. They start counting the 10 years from the time the Home Office started knowing about your existence in the UK. So that is quite a significant change. For those applying for British citizenship, you need to be aware of these things. Seek advice before you complete your British citizenship application, whether it's a naturalization application or you're applying on behalf of your child. Just get advice just to make sure you don't get caught out, because if there is something in your past, you might want to know whether it will be taken into account when your application for British citizenship is considered. Another change that we didn't talk about last time because it was not yet in force was the right of appeal for students. That has been abolished. We talked about the Immigration Act and how it was going to reform the appeals process. At that time when the last program was aired, the particular provisions had not come into force yet, and the Home Office has advised us that the appeals process will be introduced in phases. So the first category of people to be affected are students. The appeal provisions regarding students are now law. They became law in October 2014. So students who are in the UK who have valid leave to remain, when they apply for further leave to remain, if the application is refused, they will have no right of appeal against the decision. That is quite significant. The question is, what does a student do if their application for leave to remain or further leave to remain is refused? The option is to apply to the Home Office for a review of the decision. We call that an administrative review application. What it means is the Home Office is now going to take on the role of judges and actually review their own decisions in respect of applications for students. That is not very good because they are likely to come back with the same decision. If the outcome of the administrative review is still a refusal, what you then need to do is consider applying for judicial review. As I said last time, judicial review is a complex and expensive process. So to avoid being in that situation, make sure that before you put in your application, you have sought advice from a qualified professional on your application because you don't want to get caught out. If you need to speak to me about any of these changes, please contact me using the details appearing on the screen right now. So just to recap, there are changes which will affect applications for British citizenship, and there are changes that will affect students, and again, changes that will affect people who are subject to deportation. Just to quickly mention that the right of appeal for those facing deportation has been abolished, except where you fall within a few exceptions, which I will not go into because of our time. The position of the government is they want to deport first, and then people can appeal after they've been deported. But there will still be a few people who will be able to appeal in country. But for the majority of deportation cases, the idea is that the Home Office will deport first, and then your appeal can be submitted after you've been deported. So if you're affected, seek advice. In the next program, we actually move on now to talk about different types of applications that people can make, whether to come to the UK or to apply for further leave to remain. In the next program, we'll talk about applications under the so-called private life rules, what these rules are and who can apply. So keep tuned in for more on this category. Thank you for tuning in. Goodbye.